So many. You should scan the time. They scan it for you, so you're it's like someone else do it. I'm quite
Hello, thank you all for joining us both in person and virtually for this afternoon's panel, Understanding Wisconsin's State Supreme Court Election. My name is Rob Yablon, Associate Professor at UW Law School and Faculty Co-Director of the State Democracy Research Initiative, which has organized this event together with the university's Elections Research Center. I'm delighted to be moderating a discussion that could hardly be more timely. The primary election in the state Supreme Court race is this coming Tuesday, February 21st, and early voting is already underway. The primary will winnow the field of 4 candidates to 2 finalists who will square off on April 4th. The election could tip the balance of power on the Wisconsin Supreme Court for the first time in 15 years, and it comes at a moment when the court is poised to confront a range of hot-button issues. It's no wonder that the election has been garnering an unprecedented level of attention, as evidenced by the media coverage it's been receiving in Wisconsin and nationally, as well as the substantial sums of money that are pouring into the race. Our aim today is to place the election in a broader context. Our panelists, whom I'll introduce in a moment, will offer background on Wisconsin's system for electing judges, share thoughts on national trends in judicial campaigns and elections, and consider what may be at stake for Wisconsin in this race. First, some very quick housekeeping. For those of you in the room, please be aware that the panel is being live streamed and recorded with help from Wisconsin-I. For attorneys, this event is approved for 1 Wisconsin continuing legal education credit by the Board of Bar Examiners. If you're attending in person, there are CLE sign-in sheets available at the back of the room. If you haven't already done so, please make sure to sign before you leave today. For those of you attending virtually, please listen for the passcode to be given around 3:20 p.m. At the conclusion of the panel, watch for a Google Form link in the webinar chat box. Complete that form with the correct passcode by 8 p.m. Central Time today to claim your CLE credit. In terms of format, each of our panelists will begin with 8 to 10 minutes of opening remarks, and then we'll have a moderated Q&A. We invite all of you to submit questions. Given our mix of in-person and online attendees, we ask those of you here in the room to write your questions on the index cards that have been provided at your seat. We'll have folks coming around to collect those. For our virtual attendees, please submit questions using the Q&A function on Zoom, not the chat function. I'll now briefly introduce our distinguished panelists in the order they'll speak. Barry Burden is a professor of political science at the University of Wisconsin-Madison. He's also director of the Elections Research Center and is the Lyons Family Chair in Electoral Politics. His research and teaching focuses on American politics, and he brings deep knowledge of Wisconsin's political and electoral landscape. Jane Schachter, who's joining us virtually, is the William Nelson Cromwell Professor of Law at Stanford Law School. Earlier in her career, she was on the Wisconsin Law School faculty. She is a leading national expert on constitutional law and legal interpretation, with a particular focus on the role of courts in a democracy, including state judicial campaigns and elections. Miriam Seifter is an associate professor at the University of Wisconsin Law School and faculty co-director of the State Democracy Research Initiative. Her research interests include administrative and constitutional law, state and local government law, with a focus on the functioning of democracy at the state level. So with that, Barry, I'll turn it over to you.
Oh, thanks very much, Rob. Everyone can hear me. Is the mic on? Great. So I come to you as a person who's a fan of elections as a way to direct and control our democracy, but I'm going to be raising some serious concerns. I think we ought to think in a hard-headed way about whether the process we use to select Supreme Court justices in Wisconsin is the right process or the best of all of a set of imperfect processes. We've been electing judges in a nonpartisan spring election in Wisconsin since Wisconsin became a state in 1848, so a very long history of doing this. But I think the version we are observing now in February and March 2023 is not the one that would have been envisioned in the mid-1800s. So I want to talk about what I think are 3 pathologies of the current system to highlight some of the concerns. And some of these will be more obvious than others if you've been paying attention. The first is maybe the most obvious, that the nonpartisan context of the election is essentially evaporated. It's a pretense, it's a legal requirement that there are no party labels on the ballot, but I think we all have seen that parties and allied interest groups have become involved in the election. Both of the liberal candidates running this year have gotten polling services from the Democratic Party of Wisconsin. Dan Kelly, when he last ran in 2020, was essentially operating out of the Republican Party of Wisconsin's office. Jill Karofsky, who defeated him in that election, spoke at the Democratic State Convention. These are all kind of standard practices now that would have been very alarming for most of Wisconsin's history. And as a result, the way that voters choose candidates in Supreme Court elections has come to reflect their partisan biases. 20 or 30 years ago, knowing how a county voted for president would have told you almost nothing about how it would vote in the next Supreme Court race. The correlation between those two things would have been 0.2 or 0.3, where 0 means no relationship at all and 1 means a perfect relationship. That correspondence has gotten tighter and tighter over the last 25 years, and in the last several Supreme Court races, the correlation has been greater than 0.9. So almost a perfect relationship between the breakdown of the presidential vote, county by county, and the breakdown of the Supreme Court vote, even though it's nonpartisan. That's pathology 1. Pathology 2 is that these elections are decided by a very small number of highly engaged voters, and yet have massive consequence for the entire state. This, I think, has been exaggerated or escalated in the last 4 years because the political branches of government, the governor and the state legislature, have not seen eye to eye on essentially anything. Over the last 4 years, there's been very little in the way of normal policymaking, of bills being written in the legislature, sent to the governor for veto or signing. Tony Evers has set a record for the most vetoes of a Wisconsin governor. There was a year in which the Speaker of the Assembly and the governor didn't speak to one another. As a result, most of the major controversies in the state are now working their way up through the court system, and the state Supreme Court being at the top of that system, obviously. So the court has become more important, and yet it's a relatively small number of people who are going to be deciding the makeup of the court. Over the last couple of decades, turnout in the April runoff election, the general election for the Supreme Court, has ranged between about 18% and 27%. So about 1 in 5 registered voters, even a smaller number of eligible voters, are making those decisions. And in the February primary, which is coming up next week, turnout is typically half of that. 8 to 10, maybe 12% of voters deciding who the top 2 will be, who then face off in April. Occasionally, one sees higher turnout than that, and the one exception is the Supreme Court race that happened in early 2021. It became a sort of proxy for the battles over Act 10 and attitudes towards Scott Walker and everything that was happening in the state at the time. And that reached the exceptional high of 34% turnout. So that's a high watermark. I don't know if it's for good reasons or bad reasons, but we're not likely to repeat that very often. As a result, voters who do participate have to get up to speed about these candidates very quickly. This is a point I'm going to come back to in a moment. These are elections, but not like the elections we would see in a November general election with a long campaign, lots of events and voter learning. This is all accelerated in a very short period of time. So that's pathology 2, a small number of people making decisions for a large number of people. Pathology 3 is related to that one, and that is because turnout is so light, small differences in participation by different groups can have a big effect. And as a result, interested parties have tried to game the system to rev up turnout among their supporters. If you think back to the last Supreme Court election in April 2020, just as the pandemic was hitting, there was also a presidential primary happening the same day. Joe Biden was running for the Democratic nomination. He essentially had it sewed up at that point. Bernie Sanders, nonetheless, left himself in the race. His name was still on the ballot, and he was somewhat actively campaigning and probably helped juice Democratic turnout in that primary and probably helped Karofsky to victory that day. I don't know that Sanders has said that's why he remained in the race. He dropped out the day after the primary here in Wisconsin, but it seems related. This year, Democrats have tried to put an abortion measure on the April ballot in hopes that it would be connected to the Supreme Court race in voters' minds and generate turnout. Republicans in the legislature were not willing to go along with that. But for their part, Republicans have put 2 measures on the April ballot, one dealing with welfare benefits and work requirements, and one dealing with bail reform, which is an issue in the race this year. So those are all efforts, I would call them gimmicks or techniques to try to draw out voters more on one side or the other. But really, most of the work is now being done by advertising, particularly television advertising. There was one year in 2011 when Supreme Court candidates received public funding. Each candidate, if they raised money in a particular way, was guaranteed $100,000. That existed for one cycle only and then was repealed shortly thereafter. But it's just to say there are alternatives to candidate fundraising. That even that public system has some maybe perverse consequences of weighting the spending of outside groups even more than it is weighted today. But just to know that is there. And it is groups that have really caused the spending numbers to increase, and I'm sure we will see it this year. The last Supreme Court race in 2020 set a record for Wisconsin in terms of total spending. It was about $10 million, again, for one nonpartisan seat in a body of 7. That was about equally divided, $5 million between the candidates, $5 million among outside groups. Karofsky and Kelly both raised more than $2 million themselves. Karofsky's $2.7 million was the most ever raised by a judicial candidate in Wisconsin. We are going to be blowing through those numbers this year pretty easily. But if you turn back even to the early 2000s, not so long ago, it wouldn't have been uncommon for a successful Supreme Court candidate to raise only a few $100,000 and be elected to the court. There's been a little inflation, even before the spike the last year or so, but nonetheless, it's a massive increase in the amount of money involved. And that takes time for candidates, sometimes incumbent candidates, to spend time fundraising rather than doing other things. So put that in the context of what's happened this year already. The leading fundraiser among the 4 candidates is Janet Protasewicz. She has raised over $2 million as of the last reporting, which I think is through February 3rd. So it's undoubtedly more than that now. That is more than all of the other 3 candidates who are running, and will easily put her at a record pace for any candidate ever. The 4 candidates together, it seems, have raised about $5 million total through the first week of February. Again, the numbers today would be higher than that. So we're on a record pace. But it's outside groups that are actually outspending the candidates. We don't know exactly, but it looks like a counting of the number of ad orders that have been placed or already aired suggests it's about $7 million from outside groups. So you take the 5 million from the candidates, the 7 million from the groups, we're at 12 or 13 million. This is for the February nonpartisan primary, with the April election yet to come. The most expensive Supreme Court race in any state ever apparently happened in Illinois and was $15 million total. So we're approaching that at primary stage, and maybe at 20, 30 or more $1 million by April. So I don't think there is an ideal way to choose Supreme Court justices, and we might talk about that during the Q&A, but I just put these things on the table as expressions of my concern about this system. I have looked back through elections over the last 25 years in Wisconsin, and I think often the voters got it right. It seems, not being a judicial expert, it seems to me that the higher quality jurist, the more experienced judge was often chosen by voters, but that's not a guarantee, and I think even less so as spending by outside groups comes to dominate the process. Thank you.
All right, thank you, Barry. And Jane, we'll turn to you next.
Thank you. It's a pleasure to be here. Always a pleasure to reconnect with Wisconsin, if from afar this time. So, you know, we here in California and around the country are watching your election closely. And it dovetails nicely for me with recent research I've been doing into state judicial elections. So I thought I would try to give you a little bit of a national perspective. So a lot of what I'll say will track what Barry was just talking about, although not all of it. So let's start with money, where Barry left off. So between 2010 and 2020, the aggregate amount of spending around the country on state Supreme Court races doubled to about $100 million nationally. And that is fueled by some of the same factors around the country that Barry was talking about, the active engagement of interest groups on both sides, and a new kind of salience and public kind of awareness of judicial elections. One of the important things that I think has fueled this, not exclusively, but it's been kind of part of shaping the political ecosystem, if you will, is a 2002 decision by the US Supreme Court in a case called Republican Party versus White. It's an opinion written by Justice Scalia. The court split the conservatives on one side, the liberals on the other. And what Justice Scalia's opinion said was that it would violate the First Amendment for a state judicial commission to prevent candidates for office from announcing their views on legal issues. And this was a real jolt to the system. One of the reasons that that judicial elections were traditionally more sleepy affairs, where there was very little that candidates were permitted to say. And so there was a lot of banal platitudes about the rule of law and fairness and so forth, but they stayed away from they stayed away from issues. And Republican Party versus White really changed the landscape. And it's one among many factors that have made judicial elections feel and seem more like candidate elections. People are talking about issues, right? And that's kind of new and different. And some thought that was a real threat to the impartiality of the court, or the perceived impartiality of the court, but the Supreme Court went the other way on that. One of the things I looked at recently was 230 state Supreme Court elections around the country held between 2016 and 2021. And I was trying to get a sense of kind of what those elections look like. And in some ways, they look like what's been described in Wisconsin, and in other ways, less so. Certainly, the increasing nationalization, that is the correlation Barry talked about, between vote choice for president or governor and a vote choice for Supreme Court justice has been steadily rising. We see as well, unlike Wisconsin, a number of states around the country are one-party states where there's a so-called trifecta. In other words, all branches are the executive and the legislative branches are controlled by the same party. And we tend to see, not exclusively, not universally, but much more likely to see that the same party controls the judicial branch and the state Supreme Court. And so all of this, I think, is a way of saying that state Supreme Courts have become more visibly and tangibly connected to the politics of their states. Now, what's, I think, unusual about Wisconsin, compared to very different anyway than these one-party states, right, is that it's a closely divided kind of 50-50 state. People think that Wisconsin may decide presidential elections. People understand that state Supreme Courts get cases about presidential elections, and that really fuels, I think, a lot of the national attention. But okay, and then one other thing I just want to say is that this whole phenomenon of the increasing polarization, nationalization, politicization of state Supreme Court elections can only be further accelerated by the Dobbs decision, right? Which makes us turn our eyes to state Supreme Courts and state ballot measures to know where the next moves might be on the, kind of sui generis issue of abortion, right? So that's only kind of juicing all of these trends. Now, if we view this from the standpoint of, everything in our politics is more divisive, more polarized, more bitterly contested, why should we be surprised to see judicial elections follow the same pattern? It sort of makes a certain amount of sense. But there is an interesting fact, and this will build again on something that Barry mentioned, which is that only a small handful of states have candidates who run with a party identification. So 8 states now have candidates for Supreme Court run with an R or a D by their name. And an additional state, Michigan, has the candidates run in a partisan primary and then run in a nonpartisan general election. So how did these nominally nonpartisan elections end up so closely correlated with partisan power in the state when the candidates are forbidden in most states from identifying themselves with a party. Some of this will build on what Barry started to say. In a state, in one-party states, right, where there is a trifecta, right, it's most likely that the winning candidates are gonna be associated with the same party. How do voters learn that, either in a divided or a one-party state? Well, they learn it through various mechanisms of partisan signaling. So often a candidate has been appointed to a vacancy by the governor, so the voters will know which governor appointed that candidate. Sometimes we have prior office holders running for judicial election. That's another way of revealing partisan identification. But what is much more, I think, pervasive is the kind of language that's used by candidates and about candidates. So, for example, when I looked at these elections from 2016 to 2021, there were just a long list of examples of candidates identifying themselves, for example, as conservative, as fiscal conservatives, sometimes as Christian conservatives in nonpartisan elections. They weren't calling themselves Republicans, but it's very clear where they were coming from. Increasingly, I think we're going to see on the other side candidates identifying themselves as progressives. Okay, so they're using a different adjective, but everybody understands how that lines up in terms of party ID. And then there's other things that sort of feed into this. So candidate endorsements in Wisconsin in 2020, Biden endorsed one candidate, Trump endorsed the other candidate. Right, senators very commonly endorse candidates for state Supreme Court in their home states. Interest group endorsements, pro-life, pro-choice, Chamber of Commerce, labor. Those are sort of familiar parts of elections. Certain kinds of language, which is, familiar from judicial debates on the federal level, judicial activism and legislation from the bench. Those are sort of conservative frames that have been used over the decades. Query whether in the wake of cases like Dobbs and the current Supreme Court, we'll start to see progressives talk about judicial activism, but that's generally been a frame that's come from one side. So that's another kind of efficient way of signaling. So voters figure it out, albeit that smaller number of voters who are interested and who are following it, and maybe who take less information to figure it out because they're politically engaged and paying close attention. So that does raise questions, and again, we can talk about it in the Q&A about the efficacy of nominally nonpartisan elections. Would it be better to have partisan elections? Would it be better to depart from elections entirely? We can talk about that if folks are interested. The other thing I just wanted to briefly touch on, I mentioned at the beginning the Republican Party versus White case. That was the First Amendment case saying judges must be permitted to announce their views on legal issues during a campaign as a matter of free speech. I understand that there is a dispute in Wisconsin now about one of the candidates. Has that person said too much? Has that candidate stepped over a line? And just to understand a little bit about the legal framework that would govern that, the distinction that has arisen since the Republican Party versus White case is candidates on the one hand are permitted to announce their views on an issue. On the other hand, they're not permitted to pledge or commit to decide a case a certain way, a particular case a certain way. And so what ends up happening is we're policing a line between have they announced their view on a general legal issue, or have they promised that when this case comes before me, this is how I will rule. And it's not that difficult for candidates to say, I'm not making any promises about how I'll come out. I just think you're entitled to know what I think about this issue, which was the logic of the Scalia opinion. That is to say, once a state decides to have judicial elections, you can't muzzle the candidates from telling the voters something about what they think, and that it's unrealistic to think that a candidate for a state Supreme Court or for judicial office will come to the bench with a total blank slate and no views about any issues. That's just not really realistic, right? So all of that sets up that important distinction, but leaves for later in the process questions about whether, for example, a candidate has to recuse from a particular case, and there's some law associated with that as well. But the key distinction is between announcing a view, A-OK, committing or pledging in advance to decide a case a certain way, problematic. Okay, leave it there. Thanks.
So thank you, Jane. And we'll turn it over to Miriam in a second. First of all, let me just say, some of you who are online noted that there were some issues between Jane's camera and the Lubar Commons camera. Hopefully we did get that resolved, and hopefully you can now hear me okay. Let me also just say, for those of you who want to submit questions, if you're in the room, please remember to fill out your note cards, and those can be brought up to me. And if you're online, please go ahead and submit questions using the Q&A function. And with that, I'll turn it over to Miriam.
Okay. I'm going to try to mitigate the audio issues by talking loudly into the mic. And if Rob gets a comment that you can't hear me, I'm sure he'll give me a swift elbow. So thank you again all for being here today, both in the room and online. And thanks to my colleagues at the State Democracy Research Initiative and the Elections Research Center for organizing. My topic is about the court's work. To give a sense of what's at stake in the election, I'll cover a little bit about what the court does, and then turn to a few major matters that are on the horizon: abortion, redistricting, and other cases affecting the balance of power in state government. And for each of these, I'll try to describe the current legal lay of the land and then what could come next. So let's just start by considering big picture, what does the Wisconsin Supreme Court do? And we can start by thinking about its docket. The court issues roughly 50 to 60 published opinions a year on its merits docket. And unlike the cases I'm going to talk about today, the bulk of the court's work is not what we would think of as hot button issues. But that's not to say it's insignificant. In fact, even in its lower profile cases, the court does tend to have a major impact on people's lives. In a typical year, something like 30 to 40% of the docket is criminal law cases. And of the remaining civil cases, these are matters that range from land use to insurance to family law. Not always flashy, but it really is the state court system more than the federal court system that affects people's day-to-day lives. State courts decide over 90% of the cases in our country. They are how most people experience the legal system. Another big picture point is about the court's justices. The court's 7 justices today are notably divided in their rulings. One way to look at this is to track the number of unanimous opinions that the court issues. We at SDRI have a project collecting data from state Supreme Courts nationwide. And one thing that we can see is that 35 years ago, the justices were unanimous about 80% of the time. That's a lot. 25 years ago, they were unanimous in around 70% of cases. Last year, unanimity was more of the exception. The justices decided a case without a dissent only something like 37% of the time. Moreover, the cases are not just divided, but closely divided. The court decided more cases 4-3 in its last term than ever before. And with Justice Rogan-Sack retiring, those 4-3 decisions are ones that could potentially come out in the opposite way, which is part of why the election is getting so much attention. So let's take a closer look now at some of these big ticket issues. I'll first discuss abortion. When the Supreme Court of the United States issued its Dobbs decision in June 2022 and reversed Roe versus Wade, it said that it was leaving the issue of abortion to the states. And states have responded in various ways all around the country. In some states, they've responded with new protections or with constitutional amendments. In many states, litigation has ensued. Wisconsin is one of the states with pending litigation, and the case that I'm going to describe is now pending in Dane County Circuit Court. And I'll briefly describe it so you can see what could come before the Wisconsin Supreme Court. This is a lawsuit that Attorney General Josh Kaul brought last summer, arguing that Wisconsin's 1849 near total abortion ban is no longer in effect and cannot be enforced. The Attorney General is joined by a group of physicians as interveners in the case who likewise ask the court to declare the law unenforceable. The Attorney General advances two legal theories in the case. One is what's referred to as implied repeal. The argument there is that more recent abortion laws in the state conflict with and therefore supersede the 1849 ban. These include laws from the 1980s that recognize and regulate legal abortion and have broader exception for the mother's health. Courts generally try to avoid finding implied repeals when possible. But here, the Attorney General says that abortion is either banned or it's not, and that the more recent laws therefore must replace the earlier inconsistent ones. The other legal theory in the case is a doctrine known as desuetude. It's a doctrine of disuse. And its animating idea, sounding in fair notice, is that if a law has not been enforced for a really, really long time, it would be unlawful to suddenly do so. Now, desuetude is a rarely used doctrine, but the Attorney General argues that this is precisely the sort of case when it applies, arguing that the 1849 law is an example of a so-called zombie law that remained on the books in part because everyone recognized that it was unconstitutional and therefore unenforceable. The case has been moving fairly slowly at the circuit court level, so it seems likely, at least at this pace, that it will be the newly composed Wisconsin Supreme Court that would hear it, although that's somewhat speculative. And of course, the existence of this suit doesn't mean that there couldn't also be others that pop up and might be on a different timeline. Okay, second issue I'll cover is redistricting. So where do things stand with Wisconsin's electoral maps? Like abortion, this is a legal issue that has come up all around the country, and it's another reason that state courts generally are getting so much attention. In the United States Supreme Court's 2019 decision in Rucho versus Common Cause, the Supreme Court said that extreme partisan gerrymandering is a non-justiciable political question at the federal level. In other words, a type of case that the federal courts cannot hear. But the Rucho case also expressly noted that it's the kind of issue that state courts could hear and were hearing under state constitutions. Now, Wisconsin came into its latest round of redistricting litigation with maps that were sort of famously among the most skewed in the country by most standard measures. But the Constitution requires maps to be redrawn every decade. And so now let's fast forward to last year. The job of drawing new lines falls to the legislature and the governor in Wisconsin. But if they reach an impasse, courts can step in as fallback or remedial line drawers. After the 1980, 1990, and 2000 census, it was a federal court that ended up redrawing the lines or drawing the lines. But this time around, litigants brought the matter to the Wisconsin Supreme Court, the state Supreme Court, and the court decided 4-3 to take it on as an original action. And the resulting case was called Johnson versus WEC. Now, the Johnson litigation proceeded in two stages, and I'll focus more on the first because it was at the first and maybe more important stage that the court decided how it would choose a map. And there was a dispute about this. So some litigants argued that partisan fairness should be a factor, as is common in other courts around the country. There are also states where courts have appointed special masters or experts to draw lines. In Virginia, the court appointed there a pair of experts from opposing backgrounds to come together in an apolitical manner. And of course, there are some states that have created independent redistricting commissions. So there's all different ways to try to create neutral maps. But the Supreme Court of Wisconsin, dividing 4-3 again, cast doubt on partisan fairness as a viable criterion under the Wisconsin Constitution, and instead agreed with the legislature's proposal to use what it called a least change approach, hewing as closely as possible to the prior maps. Then at the second stage of the litigation, the court had parties submit proposed maps consistent with its least change criterion. And here I'll abbreviate a bit in the interest of time, but basically after a trip up to and back down from the Supreme Court of the United States, the court ended up adopting the legislature's proposed map, which ended up increasing the Republicans' advantage in the legislature. The resulting map appears to be the most skewed court-drawn map drawn anywhere in the country in recent decades. So what could happen next? Well, litigants dissatisfied with the current maps might bring new litigation of some sort. Formally, the only legal issue that was decided in the Johnson case was that the old 2011 maps needed to be redrawn because the 2020 census revealed they were not the districts were not equally populated. And there has been no case yet about the newest maps. There are a range of things that litigants could try to argue in a case like this. A successful claim that has worked in states like North Carolina and Pennsylvania is a claim that extreme partisan gerrymandering is unconstitutional under the state's constitution. Of course, anyone advancing such a claim here in Wisconsin would face that adverse language from Johnson that I mentioned a moment ago. There are other imaginable claims too, like that court-adopted maps must be neutral, even if legislatively drawn maps are not, or that the new maps do not adequately comply with the state constitution's compactness or other requirements, or perhaps other theories. I think for our purposes, what seems significant is that this is likely to be a live legal issue if the balance of the court changes, and that again helps explain the attention the court this election is getting. Let me briefly mention one other kind of set of issues that tends to receive less attention before I turn it back over to Rob for Q&A. So that the third set of issues to flag are cases that fall within the bucket of separation of powers. A number of varied cases that affect the balance of power within state government. These have generally been less attention getting in the news, but not less consequential. And although the subject areas vary widely, the sort of through line is the cases consider, and often, but not always, have limited the power of the governor and or state administrative agencies. So let me sort of rattle off a few examples in the interest of time, and then I'll just use one to illustrate. We can place in this sort of balance of power category everything from the challenges to the 2018 lame duck laws, which were laws that limited the power of the executive branch after Governor Evers won, but before he took office. The court largely upheld those statutory changes. Also in this category would be challenges to the authority of the governor and state health officials during the height of the pandemic. The court found such power to be limited. To the ability of the Department of Natural Resources to consider the environmental effects of high-capacity groundwater wells. There, the court upheld that power, Chief Justice Ziegler joining the majority. And also in this category might be the ability of the governor to replace holdover officials from the Walker administration who declined to leave office after their term had expired. There, the court again ruled against the governor, although the holdover recently resigned. In all of these cases and still others, the court wields a power to shape how governance operates in the state and affects how much power the executive branch retains as a co-equal branch. Now, the case I was going to spend just an extra minute on to sort of illustrate is the case of Becker versus Dane County. I see some of my state and local government law students here. We discussed this case in class. Becker confronted the question of whether to invigorate the non-delegation doctrine in Wisconsin. And that is a legal term that gets at how specific a legislature has to be when it gives a task to the executive branch to implement. At both the state and federal levels, this doctrine has historically played only a modest role. So it gives legislatures bandwidth to give agencies fairly broad instructions to tackle problems. In contrast, reinvigorating the doctrine could potentially mean that the executive branch can only take measures that the legislature has delineated or spelled out in advance. And so unlike more targeted efforts at regulatory reform, reinvigoration of a non-delegation doctrine is generally understood to be a way to restrict agency authority, to limit regulation, and to limit agencies' discretion to do things like address new public health issues or regulate water quality. The court in Becker was considering the authority of a local public health officer to issue public health orders during the pandemic. And the court answered that question affirmatively, saying that that power did exist. But it left the bigger non-delegation doctrine question open for revisitation. Justice Hagedorn's concurring opinion wrote that he, quote, remains open to more broadly reconsidering our approach to the non-delegation doctrine in future cases, a case that could easily come before the Wisconsin Supreme Court post-election. So that is a rundown of cases in which the election could make a difference, and I will turn it back over to our moderator.
All right, thank you to all of the panelists for those fantastic remarks. We'll move into Q&A now. I'm getting a lot of great questions, both from our in-person audience as well as online. A lot of the questions revolve in one way or another around the landscape across the country with respect to judicial selection methods. And so let me ask an initial one, which maybe, Jane, I'll give you the first crack at, but others can weigh in as well. First of all, there's just a descriptive aspect to this question. If you could give a little bit of the lay of the land, what do states do across the country? How many of them have elections, partisan versus nonpartisan? What are the other alternatives that states are using to elect judges? And then related to that, what, if anything, do studies show about the implications of having these different types of elections in terms of what you're getting from courts? And so Jane, why don't you go ahead first?
Sure. Yeah. So the landscape around the country reflects that, excuse me, about 38 states use some form of election for courts, but they're not all the same. So as I mentioned, about 8 or 9 use some form of partisan or semi-partisan elections. About a dozen use nonpartisan elections. A number of them use only retention elections. And so that, for example, in California, that is the way elections work. The governor appoints a justice, and then that justice has to go before the voters. But those are almost never opposed. I did an event recently with a California Supreme Court justice, and she said, basically, the decision to run for re-election involved her letting the Secretary of State know to put her name on the ballot, and that was the end of it. She didn't spend any money, she didn't do any public appearances, because it's an unopposed election. Now, back in the 1980s, 3 California Supreme Court justices, including the chief, Rose Bird, were removed against a background in retention elections, against a background where the death penalty and their refusal to uphold it had become an issue. More recently, in 2009 or so, 3 Iowa State Supreme Court justices lost their seats in a retention election after they joined a ruling supporting same-sex marriage. So it's not never. Recently in Illinois, which has partisan elections, but also retention elections, a justice was targeted by the Republican Party, and he lost his seat in a retention election. So it's not that those never turn over, but they're rarely controversial. Often the candidates are winning by 60, 70, 80% of the vote, because there's no opposition. And so I think, there are trade-offs between different kinds of systems. There are states that follow the federal model or some version of the federal model with appointment by the executive and confirmation by the legislature. There's a few outliers who do it different ways. One of the systems that I think has some virtue is a merit selection panel paired with retention elections. And I say that because, often voters don't know that much about the judiciary and about legal issues. So they're very susceptible to sound bites and, and things that sort of simplify the complexity of law. So if you have a board which is broadly representative of different segments of the population and a transparent process to deliver names to the governor, but then some recourse for voters down the road. I mean, I think we're seeing on the federal level, there's a lot of resistance to what the current Supreme Court is doing. And for many years, Republicans and conservatives have been very upset by what the Supreme Court is doing and haven't had any real recourse for justices who will be on that court, sometimes for decades and into their 90s. And so the possibility of a retention election at least gives the voters some opportunity, albeit one that will rarely be used, and that's because without opposition, it is hard to get public attention. I think there's an overarching debate about legitimacy. Frankly, voters do not want to give up their vote once they have it, and that is kind of an issue. And the last thing I'll say about this is that giving partisan elections, I think, have tremendous downsides from the standpoint of further politicization of the dynamics we've been talking about, raising more money and all those kinds of issues that we've been talking about. On the other hand, the partisan queue, the partisan identification is the single most efficient piece of information for voters. And in states where a partisan ID is provided, there is less ballot roll-off, meaning voters are less likely to vote top of the ticket races and then not vote at all for judicial races, which does happen in a lot of parts of the country. Having said that, there's a lot of trade-offs back and forth. And so I don't think there's an easy answer to this question. That maybe that's my bottom line.
Can I say
Yeah,
just a couple quick things?
Please go ahead.
I want to make sure we get to other questions, but a couple of thoughts. One I mentioned earlier is that these spring elections in Wisconsin are pretty different from a November general election because the time frame is so highly compressed. I think a lot of Wisconsin voters were surprised that we were doing elections again, having just done this in November. So you come out of the holidays and there's 6 weeks until the primary, and then a few more weeks until the general election. It's very different from, say, the governor's race last year, where the candidates were running for a year, enter a primary in August, and then you have a few months till the general election. So voters go from being completely unfamiliar with the candidates to having to choose in 6 weeks, and that's driven almost entirely by campaign advertising. So that incentivizes these groups to get involved, and I think makes something like public financing very difficult as a remedy. But I think one concern about public financing is particularly for sitting justices who are seeking re-election, that they must raise money while they are on the bench, sometimes from parties who may appear from them or have an interest in cases that come before them. My understanding is there are no real hard rules in Wisconsin about what justices do in that situation or how much time they should be devoting to the campaign activities versus serving on the court. One proposal that was floated some years ago was to put term limits on justices, maybe limit them to 1 term. So as soon as they're elected, they know that they will not be running for re-election, so there's no fundraising happening while they're on the bench. Now you might say that would disincentivize good candidates from running. Why would they want to run knowing they only get 10 years and have to leave? But the remedy for that was to make the term length longer. So to give them 13 years or 17 years, say, 1 election, you get a nice long stint on the court, don't have to fundraise ever again, and that may be your last job. So I don't know that other states are doing those things exactly, but there are some creative solutions for that.
Great, thank you. Miriam, did you want to add anything on the virtues and drawbacks of these selection methods?
I'm looking at the time. I'll try to add something just really quickly. So it is really easy to develop a long list of arguments against judicial elections. It's like extensive in the literature, and I think Barry and Jane have done a particularly good job of pointing out specific problems that are troubling. But for the sake of discussion, I guess I would maybe just offer like a little bit of the case in favor, which is to think about where state courts sit in our federal system, right? So the federal Constitution is nearly impossible to amend, and Supreme Court justices serve with life tenure. And so that's a sort of stagnant system. The state constitutional system is very different, right? State constitutions are easier to revise and amend. State courts, with the exception of Rhode Island, don't serve with life tenure. There's a few other states that are bounded by retirement ages. And so you get a sort of different feeling at the state level where there is more of a connection to the people, not in a representative capacity, of course, because judges are bounded by law, but the idea that, in comparison to the federal level, there would be a layer of courts that are a little bit more responsive to the people of the state at the margins in hard cases seems like, maybe not the worst thing, maybe possibly a healthy thing.
All right, before I get to the next questions, let me just quickly do my CLE duty for those of you who are online. If you're attending virtually and wish to receive CLE credit today, the passcode for today's event is election. Again, today's passcode is election, ELECTION. Case does not matter when you're entering this. And again, this form will be provided in the chat. We'll also provide a feedback form. We welcome you. You were able to submit feedback anonymously. And apologies again for some of the technical issues that we were having earlier. Let me also just say a quick thank you to those who have helped put this event together today, including Bree Wilde and Carrie Fisher and the rest of our teams at UW Law School, the State Democracy Research Initiative, and the Elections Research Center. Okay, so next set of questions that I want to ask, I mean, Barry started to allude to this. I've gotten several audience questions about potential reforms, and some of them actually related to public financing. You've addressed that a bit, although one question specifically was about why Wisconsin eliminated its public financing scheme. So if you're able to address that briefly. But some of the other suggestions that I've gotten in questions include, would we be better off moving these elections in Wisconsin from spring elections to November elections? Should we think of alternative voting methods like ranked choice voting? And beyond that, I'll leave it to you all if you have any other types of reforms that you think ought to be put on the radar screen. And maybe Barry, you want to take the first crack at this one.
Yeah, so there was a public financing scheme in Wisconsin under law that provided public funds to candidates, not just for the court, but of course in other offices as well. And I think it was disbanded in 2012. And there were a couple of reasons. One, I think it was not keeping up with the cost of campaigns. And the other was an ideological belief of people who were in office at the time that it was not the right thing to do with government funds. If it were the same kind of program today, I think it's pretty clear it would not keep up with the spending of outside groups. $100,000 per Supreme Court candidate is raised in a few days today by candidates, and even faster by groups. The spring versus fall tension, I don't think is easily resolved. I would have said a decade or two ago that we should keep these two sets of elections separate. At least in Wisconsin, the spring elections are cordoned off for nonpartisan offices. Supreme Court, State Superintendent of Instruction, local, county, and municipal offices, hundreds or thousands of offices selected in these February and April elections. And so there might be some benefit in protecting them from the partisan contamination of a general election, but they have become so contaminated by partisanship in the last few years that at least for the statewide offices, Superintendent and Supreme Court, that seems to me a fiction that's no longer necessary. I would have also wanted to keep partisan labels off the ballot. Even though they have some benefits that Jane mentioned, they do increase turnout and they often help voters find the candidate that is the right one for them. But that also is not much of a limitation any longer, as the advertising and the positions of the candidates have become so much clearer. So unfortunately, I don't think there are easy remedies. There's certainly no silver bullet.
Miriam, any favorite reforms?
Let you get to the next question.
No.
Jane has one.
Yeah, Jane, did you want to add anything to what
Yeah,
Barry has to say?
just a quick two quick comments. One is just a reform that some states are pursuing that I think is a bad idea, which is to create districts for Supreme Court justices. Most states that elect justices do it on an at-large basis, and so that everybody in the state votes. But some states recently have been considering breaking their Supreme Court down into districts. And I think that really raises the risk of the same kind of gerrymandering that we're seeing on the political level. So that's a sort of an anti-reform.
Thank you. So another question that I've gotten a couple of different variations on addresses the implications of these increasingly partisan ideological elections for the rule of law and for the role of courts in our society. And maybe, Miriam, we can let you kick this one off. Should we be troubled by the rising polarization of these judicial elections? Does it make it more difficult for courts to do their work? Is this an indication that courts should actually be doing less, as they do in some places? Is part of the problem here that we've given courts in this country outsized authority?
I think probably not. Of course, I think there are lots of concerns that polarization and sorting and all of that raises. And so too, there are concerns with campaigns that become highly partisan in their rhetoric. But I think fundamentally, as I sort of alluded to before, state courts serve an especially important role in this country. They, not only because they're the courts that sort of serve people the most in relatively day-to-day matters, but also because they are the most accountable courts that we have. And then again, in a federal system in which the federal judiciary doesn't operate that way, I think it would be a shame to limit state courts in the same way. So I think the hope is that it becomes attractive to elect judges, not just because, you think that they sort of align with certain prior beliefs that you have, but because, as Barry said before, but because you think that they have sort of the requisite experience and will, do their very best with the law. I would also just add that being a state court judge, I think, is really difficult. State constitutions, which is what I study, are really long and complicated, and there are lots of hard questions that come to the court. But in a system like that, it's not clear that what you want to do is take those issues away from courts rather than try to elect, and I would add, and re-elect or not re-elect judges who will do their best to implement that system faithfully.
Jane, do you want to add anything about some of the rule of law implications of increasing polarization?
Yeah, I would just say two things. One is that if we contrast elections to an appointed system, we just have to think about contemporary debates about the Supreme Court, where many people are increasingly unhappy with the Supreme Court and feeling like they are, not following rule of law principles like stare decisis. And this is the political winds in relation to the U.S. Supreme Court are shifting, but we've had these battles, over the years without electing justices. And so I think some of those really are hard kind of core questions, and they go to fundamental questions about, legal realism and formalism, and what does it really mean to honor the rule of law. So I think that the other thing I'll say is that I don't think public perceptions of legitimacy are necessarily damaged by elections. In some sense, in some studies, legitimacy is increased by the fact of elections, although it can depend upon what's going on in that election. And certainly the influx of big money is a threat to that.
Sorry, I may have been muted there for folks who were online. Apologies. So some of the ethical questions that arise related to judicial campaigns, and this intersects in some ways maybe with these questions about legitimacy. And Jane, you got into this a little bit in your remarks. Are there changes that we should make to judicial ethics rules or codes? What are some of the concerns that may arise in terms of recusal down the road when judges are making some of these statements on the campaign trail or accepting large donations from certain groups? How should we think about that? And Jane, if you want to
Sure.
take a first crack at that.
Sure. Couple things to say about that. One is, as far as what the Supreme Court has said, we talked about Republican Party versus White. You can announce your view, but not pre-commit on a case. There have been a couple of cases also about campaign contributions, and one of them says that judges can't personally solicit campaign funds. That doesn't end up meaning that much, because in the same decision they say it's fine for a judge to write a thank you note acknowledging a contribution. So clearly the judge, knows about the contribution, even if a committee solicited it instead of the judge herself. There's also a case called Caperton, which says that at some point, in that case, there was a massive tens of millions of dollars given to a candidate who ended up on the West Virginia Supreme Court being the deciding vote in a 3-2 decision that was favorable to a company that knew that decision was on its way to the Supreme Court when it chose to spend these jillions of dollars to try to elect that candidate. And the Supreme Court said in that case, there can be some cases that are so extreme that it violates due process for a judge not to, in that case, recuse himself. These are kind of, these are limited interventions. A lot of it is left to judges themselves to decide whether to recuse. Some states do have rules. Wisconsin, I believe, is not one of them. Some states do have rules that say if a judge accepts over a certain number of dollars, they must recuse from a case. And I think that is something that states ought to be taking a hard look at.
Thank you. And Miriam Rivera, did you want to add anything on ethics, reforms, recusal?
Did we do something wrong?
I don't know.
I agree with Jane.
Okay. Thank you. Well, we're down to our final minute. We probably don't have time for more questions, except there are a couple of very discrete ones that I might be able to help us with, actually. There was a question about whether there are other countries that have judicial elections. This is pretty much a uniquely American phenomenon. Is there anywhere else that does it?
Not that I know of.
No. There was also a question about how many terms Wisconsin Supreme Court justices can run for. And the answer is that they can continue to serve. We don't have a retirement age here as they do in some states, and there are not term limits in Wisconsin either. Okay, well, since we are at time, I just want to thank the panelists again for their presentations and for answering these questions. Thanks to all of you for joining us today. A reminder to those of you who are joining us in person, there are refreshments in the back, so please stick around afterwards. For those of you at home, I'm afraid you're going to have to raid your own pantries and refrigerators. Enjoy the rest of the afternoon, and thanks again.